Hello everyone, welcome back to our Learning Legal English through Case Laws series. In this video, we will study Case Law NO.18/2018/AL, about on the ACT of murder of on-duty officer and the crime of murder. Part 1, Source of the Case Law. Part 2, Overview of the Case Law. Part 3, Content of the Case. Part 4, Assessment of the Court. Part 5, Rules. This case law was adopted by the Judicial Council of the Supreme People's Court on October 17, 2018 and promulgated under Decision No. 269/QDCA dated November 6, 2018 by the Chief Justice of the Supreme People's Court. Appellate Judgment No. 331/2018/HSPT dated May 28, 2018 of Superior People's Court of Hanoi on the murder case with the defendant being Mr. Phan Thanh H., other name, D., born in 1995, residing at Si Commune, D District, Binh Dinh Province, having his address at B Hamlet, Si Commune, D District, Binh Dinh Province. Victim, Mr. Nguyen On D. Overview of the case law. Background of the case law. The defendant was ordered by the traffic police to stop the vehicle to settle the violation but failed to follow such order and drove the vehicle straight through the traffic police officers. When the traffic police officer clung to the rearview mirror of the vehicle, the defendant continued to drive the vehicle with high speed, unexpectedly steered close to the median strip in order to knock the traffic police officer down to the road. The traffic police officer fell off the vehicle, hit the hard median strip in the middle of the road, and suffered multiple injuries. Legal resolution. In this case, the defendant shall be liable for the crime of murder with the sentencing framework factor being murder of on-duty officer. Part 3 Content of the case. Implementing a plan of the Traffic Police Department of Ha Tinh Province, PC 67, on June 30, 2017, the patrol squad including officers Vo Hong En, Nguyen On D, Lo Ho Viet A and Duong Hai En, Officer Vo Hong Nam is the head of this squad, conducted patrol duties, handled violations relating to traffic safety from km 468 to km 517 of the 1A National Highway. Officer Duong Hai En was assigned the duty of using the vehicle speed detector number UX027957 to measure the speed of vehicles at km 11 plus 450 of the road bypassing Ha Tinh City. Within H Commune, I District, Ha Tinh Province. Officers Vo Hong En, Nguyen On D and Lo Ho Viet A were assigned to stop, examine, patrol and handle violating vehicles at 1A km 488 plus 650 of the 1A National Highway, within K Commune, L District, Ha Tinh Province. On June 30, 2017, Tu Tsong T and Phan Thanh H operated the towing truck BKS 77C016.47 towing a semi-trailer BKS 77 or 001.37 driving from south to north. When reaching the area of Quang Binh Province, the vehicle was operated by Phan Thanh H and Tu Tsong T was sleeping in the truck cab. At 15:28 on the same day, while Phan Thanh H was operating the vehicle to km 11 plus 450 in the road bypassing Ha Tinh City, Officer Duong Hai En used the vehicle speedometer and detected that the towing vehicle operated by H violated the speed limit of 66/60 km/h. So he reported and sent images of the violation via mobile phone message to the patrol squad who were on duty at km 488 plus 700 of the 1A National Highway to handle. At 16:05 on the same day, when the towing vehicle BKS 77C016.47 operated by Phan Thanh H arrived at km 488 plus 650 of the 1A National Highway, within K Commune, L District, Ha Tinh Province. He was signaled to stop by the patrol of the Traffic Police Department of the Police of Ha Tinh Province. After Phan Thanh H had stopped the vehicle, Officer Nguyen On D informed and showed images of the violation to him and asked him to present documents. Nonetheless, Phan Thanh H asserted that his vehicle did not violate the speed limit, so he did not present documents and then argued with Officer D and other officers in the patrol squad who were on duty. At the same time, Phan Thanh H took his mobile phone displaying images of his vehicle's speed to compare. The patrol explained, but Phan Thanh H still did not accept and continued to argue, then climbed up the vehicle and closed the door. The vehicle was still running. At this time, Officer Lo Ho Viet A was standing before the front right side of the vehicle. Officer Nguyen D was standing before the front left side of the vehicle BKS 77C016.47 at about 01 meter, gave Fontan H a signal not to drive the vehicle. However, Fontan H failed to comply with such order and unexpectedly drove the vehicle straight through Officer LUhet A and Officer Nguyen D standing before the front of the vehicle to escape. Seeing that, Officer LUhet A avoided by jumping to the right roadside, Officer Nguyen D failed to do so. Thus, he had to cling to the front left rearview mirror on the hood of the vehicle. Even though Fontan H saw that Officer Nguyen D was clinging to the rearview mirror, he still continued to accelerate the vehicle. When it came to km 488 plus 250 of the 1A National Highway, approximately 400 meters from the starting point, Fontan H's vehicle was moving in the right lane. Although there was no obstacle and no car traveling in the same direction before him, H unexpectedly steered heavily to the left, changed the direction of the front of the vehicle close to the hard median strip in the middle of the road, aiming to knock Officer Nguyen D down to escape. At that time Officer Nguyen D was clinging onto the rearview mirror with both of his hands. His legs did not have any support, so when the vehicle was unexpectedly steered, he was thrown off the vehicle and hit the hard median strip, then fell onto the road surface. After unexpectedly steering and throwing Officer Nguyen H onto the road, Fontan H still did not stop, continued to operate the vehicle to escape, failed to comply with the order to stop from the patrol squad. Only at km 488 of the 1A National Highway, when the traffic police force of the police of Ha Tinh province used specialized vehicles to block him, Fontan H then stopped the vehicle but still did not comply and continued to argue with the on-duty officers. He then got on the vehicle, closed the door refusing to cooperate, then operated the vehicle to block the road causing traffic jams. The police department of L District, cooperating with the traffic police department of the police of Ha Tinh province, compelled Fontan H to operate the vehicle to the roadside and brought him to the police office of L District to handle. Consequence: Officer Nguyen D was seriously injured and was taken to the General Hospital of Hon Linh Commune, then transferred for treatment at the Via Duc Friendship Hospital. On July 10, 2017, he was transferred for treatment at General Hospital of Ha Tinh province and was discharged from the hospital on July 18, 2017. The process of Fontan H carrying out such acts was recorded via a mobile phone by Mr. Tran Trung D, residing at 102 M Street, N District, Hanoi, who was a passenger on a taxi BKS 37A304.84 of My Linh Taxi. In Report on Forensic Medical Examination No. 87 dated September 18, 2017 of the Forensic Medical Examination Center of Ha Tinh Province as to Mr. Nguyen D's injuries, it was determined that, plus traumatic brain injury, left frontal lobe impacted, right vertebral bone being fractured, plus top of the head with scar wound size of 2.5 cm x 0.2 cm, right temporal lobe with scar wound of 1.5 cm x 0.2 cm, plus X-ray image of 1/3 left fibula being broken having bony callus. Conclusion: the current injury level of the body caused by this incident is 40%. BL 139-140. During the investigation process, Fontan H presented that the vehicle operated by H did not violate the speed limit, based on the VTR-01 travel monitoring device installed on the towing vehicle BKS 77C016.47, reflecting that, on the road bypassing Ha Tinh City, the towing vehicle BKS 77C016.47 traveled at a speed less than 60 km per hour. However, VTR-01 travel monitoring device installed on the towing vehicle BKS 77C016.47, which meets the national standards QCVN 31:2001/GTVT issued in accordance with the Circular No. 08/2011/TTB-GTVT dated March 8, 2011 of the Ministry of Transport, has plus or minus 5 km per hour error and updates the vehicle speed every 10 seconds. Meanwhile, the vehicle speed detector number UX027957 verified according to the Certificate of Accreditation No. V08.KD.525.16 dated September 29, 2016 of Vietnam Metrology Institute, has technical features of measurement as follow: range of measurement of 8 to 320 km per hour, accuracy level plus or minus 2 km per hour, and direct measurement of the speed of the traveling vehicle. In this case, Fontan H was responsible to comply the order, present documentations in compliance with the requests of the on-duty officers. If he disagreed with the result of the resolution, then he could submit a complaint. However, due to the fear of being detected that he was using a forged driver's license, Fontaine H. did not comply and committed a crime. As to the acts of forging documents of agencies and/or organizations. Around October 2016, Fontaine H., having a Class C driver's license, was accepted by Tu Song T to be an assistant driver of towing vehicles to come with T to deliver goods. During process of being an assistant driver, Tu Song T saw that H can operate towing vehicles, but Fontaine H was not old enough to be licensed with a Class FC driver's license. Around February 2017, Tu Song T took Fontaine H's photo and contacted a stranger in Haiphong City to forge Class FC driver's license No. 520144004729 having the name of LUient C and photo of Fontaine H with the price of VND2 500,000 and then handed it to H to use in dealing with and deceiving when being inspected by competent authorities. On June 30, 2017, when working with the investigation police agency of the Police of L District, Fontaine H has presented a forged Class FC driver's license named LUient C, born in 1991, residing at O Town, D District, Binh Dinh Province. At the same time, both Fontaine H and Tu Song T stated that H's name is LUient C in order to deceive investigation agency. Therefore, the investigation police agency of the Police of L District issued legal procedure decisions against Fontaine H with the fake name of LUient C. During the investigation, it was also determined that, at 1650 on April 22, 2017, at km 1060 plus 400 of the 1A National Highway within Quang Ngai Province, Fontaine H operated the towing vehicle BKS 77C103.69 towing a semi-trailer 77 or 014.65 and violated turning without signaling and used forged driver's license number 520144004728 with name LUient C to deceive the patrol squad of the Traffic Police Department of the Police of Quang Ngai Province. With the above-mentioned acts, in the indictment No. 35/CTR, KSDT, on October 13, 2017, the People's Procuracy of Ha Tinh Province prosecuted Fontaine H for the crime of murder pursuant to Article 93.1d of the Criminal Code and the crime of forging documents of agencies and/or organizations pursuant to Article 267.2b of the Criminal Code. It also prosecuted Song T for the crime of forging documents of agencies and/or organizations pursuant to Article 267.2b of the Criminal Code. In first instance criminal judgment No. 39/2017/HSST dated December 26, 2017, the People's Court of Ha Tinh Province ruled to 1. Convict the defendant Fontaine H of the crimes of murder and forging documents of agencies and/or organizations and the defendant Tu Song T of the crime of forging documents of agencies and/or organizations. Apply Article 93.1d, Article 52.3, Article 267.2b, Article 46.1b, and p, and Article 46.2, Article 47 of the Criminal Code 1999. To sentence the defendant Fontaine H with 0.88 years of imprisonment for the crime of murder and 0.22 years of imprisonment for the crime of forging documents of agencies and/or organizations. Apply Article 50.1 of the Criminal Code to combine the penalties of 0.2 crimes to compel Fontaine H to bear the combined penalty of 10 years of imprisonment. The imprisonment period shall be calculated from the date of temporary custody and detention, June 30, 2017. Apply Article 267.2b and Article 46.2 of the Criminal Code 1999, sentence the defendant Tu Song T with 0.22 years imprisonment. The imprisonment time limit shall be calculated from the date the defendant implements the sentence. In addition, the first instance court also determined on handling the exhibits, the court fees and right to appeal. On January 3, 2018, the defendant Fontaine H submitted an appeal requesting to reduce the level of punishment. The defendant Tu Song T submitted an appeal requesting to reduce the level of punishment and a suspended sentence. At the hearing, the defendant Fontaine H had confessed and admitted to all the acts of murder and acts of forging documents of agencies and/or organizations as stated above. The defendant presented that the first instance court's sentence was too strict and proposed the Council of Adjudicators to reduce the level of punishment for the defendant. The defendant Tu Tsong T had confessed and admitted to all the acts of forging documents of agencies and/or organizations as stated above. The defendant presented. The defendant did not have prior criminal record and committed a less serious crime, sincerely cooperated, has repented, compensated the damage. The defendant's family was facing hardship. He requested that the Council of Adjudicators to allow the defendant to rehabilitate in his locality. Part 4 Assessment of the Court. The testimonies admitting guilt by the defendants Phan Ton H and Tu Tsong T match with the testimony of the crime victim, the testimonies of the witnesses, the expert report and other documents or evidence of the case file. Therefore, there is sufficient basis to conclude, at around 16:05 on June 30, 2017, the defendant Phan Ton H operated a towing vehicle BKS 77C016.47 towing a semi-trailer BKS 77 or 001.37, while arriving at KM 488 plus 650 of the 1A National Highway, within K Commune, L District, Ha Tin Province. Then it was signaled to stop by the patrol squad of the Traffic Police Division of the Police Department of Ha Tin Province for a speed violation, 66/60 km/h. The defendant Phan Ton H did not comply since he asserted that his vehicle did not violate speed limit, so he argued and drove the vehicle straight through Mr. Nguyen D and Mr. LUhet T being on-duty traffic police officers when they were standing in front of the vehicle. Mr. LUhet T jumped to the roadside and escaped, while Mr. Nguyen D had to cling onto the front left rearview mirror of the vehicle. Phan Ton H continued to drive the vehicle at high speed, then unexpectedly steered heavily to the left, which was close to the median strip in the middle of the road, aiming to knock Mr. Nguyen D down to escape. The consequence was that Mr. Nguyen D fell off the vehicle, hitting the hard median strip in the middle of the road, then falling off onto the road. Phan Ton H let the consequences happen and then continued to escape. Mr. Nguyen D had traumatic brain injury, broke his legs, having 40% injury level. Phan Ton H and Tu Tsong T also committed the following acts. The defendant Tu Tsong T acknowledged that the defendant Phan Ton H did not have Class FC driver's license and was not old enough to be licensed with a Class FC driver's license, but Tu Tsong T has hired a man in Haiphong, T did not know the name and address, to forge Class FC driver's license number 520144004729 with image of Phan Ton H, but with name Lu Van C. He handed it to H to use in dealing with and deceiving competent authorities when operating vehicles on the road. With the forged driver's license provided by Tu Tsong T, Phan Ton H used that forged driver's license twice to deceive the Traffic Police Department of Quang Ngai Province and the police of El Commune, Ha Tin Province. Tu Tsong T was aware of Phan Ton H's acts of using a forged driver's license to deceive competent authorities as stated above. Given the above-mentioned criminal actions, the first instance court convicted the defendant Phan Ton H for the crime of murder and the crime of forging documents of agencies and/or organizations. The crimes and sentences are specified in Article 93.1 d and Article 267.2 b of the Criminal Code 1999, which there is basis and is correct with law. The defendant Tu Tsong T was convicted with the crime of forging documents of agencies and/or organizations with crimes and sentences as provided in Article 267.2 b of the Criminal Code 1999, which has basis and correct with the law. Considering the appeals of the defendant Phan Ton H and Tu Tsong T, the Council of Adjudicators found that the act of murder committed by the defendant Phan Ton H was dangerous, directly infringed on human life, negatively impacted the order and safety of public transportation. The act of forging documents of agencies and/or organizations committed by the defendants Tu Tsong T and Phan Ton H directly violated administrative management order, therefore, it must be strictly punished before the law. The defendant Phan Ton H has a good personal record, with no prior criminal record. During the investigation and at the hearing sincerely cooperated, repented, voluntarily compensated the victim to remedy consequences. The victim requested to reduce the level of punishment for the defendant. The defendant was facing hardship, being of a poor household in the locality. The criminal acts committed by the defendant fall into the category of incomplete crime. In addition, the defendant also has a grandfather who contributed to the revolution and entitled to similar regime as war invalids. As such, the defendant Fontaine H is entitled to mitigating factors in accordance with Article 46.1 B and P and Article 46.2, Article 18 of the Criminal Code 1999. Therefore, there is basis to reduce the punishment level for the defendant of the sentence for the crime of murder, but the sentence for the crime of forging documents of agencies and/or organizations is upheld. As to the defendant Tu Son T, has a good personal record, with no prior criminal record. During the investigation and at the hearing sincerely cooperated. Repented, the defendant with the defendant Fontaine H's family compensated the victim to remedy consequences. The defendant was facing hardship and is the main laborer in the family. The defendant has a fixed residence. Considering the above, imprisonment is unnecessary, and rehabilitation of the defendant in his locality also satisfies the conditions to educate the defendant and for general prevention. Therefore, there is sufficient basis to accept the appeal of the defendant Tu Son T. Other rulings of first instance judgment not being appealed or protested shall become effective upon the expiration of the time limit for appeals and protests. The defendants Fontaine H and Tu Son T do not need to bear legal costs for appellate criminal procedure. In light of the foregoing, pursuant to Article 355.1 B, Article 357.1 E of the Criminal Procedure Code 2015, Rules 1. To accept a part of the appeal of the defendant Fontaine H, amending the first instance judgment. Applying Article 93.1 D, Article 267.2 B, Article 18, Article 52.3 Murder, Article 46.1 B and P, Article 46.2, Article 47, Article 50.1 of the Criminal Code 1999, to sentence the defendant Fontaine H with 0.77 years of imprisonment for the crime of murder and 0.22 years of imprisonment for the crime of forging documents of agencies and/or organizations. The combined penalty of the 0.2 crimes is 0.99 years of imprisonment. The imprisonment period shall be calculated from June 30, 2017, to accept the appeal of the defendant Tu Son T, amending the first instance judgment. Applying Article 267.2 B, Article 46.1 B and P, Article 46.2, Article 60 of the Criminal Code 1999, to sentence the defendant Tu Son T with 0.22 years of imprisonment with suspended sentence for the crime of forging documents of agencies and/or organizations. The probation period is 0.44 years upon the date of pronouncement of the appellate judgment. The defendant Tu Son T is assigned to the People's Committee of O Town, D District, Binh Dinh Province, for supervision and education during probation. Where the person with a suspended sentence changes residence, it shall be implemented in accordance with Article 69.1 of the Law on Criminal Judgment Enforcement. 3. Other rulings of first instance judgment not being appealed or protested shall become effective upon the expiration of the time limit for appeals and protests. The appellate judgment shall become effective upon the date of pronouncement of the appellate judgment. The testimonies admitting guilt by the defendants Fontaine H and Tu Son T match with the testimony of the crime victim, the testimonies of the witnesses, the expert report and other documents or evidence of the case file. Therefore, there is sufficient basis to conclude, at around 16:05 on June 30, 2017, the defendant Fontaine H operated a towing vehicle BKS 77C016.47 towing a semi-trailer BKS 77 or 001.37, while arriving at KM 488 plus 650 of the 1A National Highway, within K Commune, L District, Ha Tinh Province. Then it was signaled to stop by the patrol squad of the Traffic Police Division of the Police Department of Ha Tinh Province for a speed violation, 66/60 km/h. The defendant Fontaine H did not comply since he asserted that his vehicle did not violate speed limit, so he argued and drove the vehicle straight through Mr. Nguyen D and Mr. Laho Viet being on duty traffic police officers when they were standing in front of the vehicle. Mr. Laho Viet A jumped to the roadside and escaped, while Mr. Nguyen D had to cling onto the front left rearview mirror of the vehicle. Fontaine H continued to drive the vehicle at high speed, then unexpectedly steered heavily to the left, which was close to the median strip in the middle of the road, aiming to knock Mr. Nguyen D down to escape. The consequence was that Mr. Nguyen D fell off the vehicle, hitting the hard median strip in the middle of the road, then falling off onto the road. Fontaine H let the consequences happen and then continued to escape. Mr. Nguyen on D had traumatic brain injury, broke his legs, having 40% injury level. 3. Given the above-mentioned criminal actions, the first instance court convicted the defendant Phan Ton H for the crime of murder and the crime of forging documents of agencies and/or organizations. The crimes and sentences are specified in Article 93.1 d and Article 267.2 b of the Criminal Code 1999, which there is basis and is correct with law. Thanks for watching, goodbye, and see you again.